as long as they say, this is all we're going to ask for, and this is our specific amount alleged to be owed, that makes it an amount the carrier can accept and a case can settle without litigation.
Isn't that all this is to give the insurance company some cover so that when the number is received, the insurance company has the option to decide at that point, is this something we want to put in and pay, or do we want to do something else?
Yes, a straight answer in terms of the specific amount alleged to be owed on the claim. The statute does not speak in terms of a specific amount or an amount. It says the specific amount. And when the pre-suit notice letter complies with the statute, it becomes an offer that a carrier can accept, and then the case is resolved. Looking at these letters again more carefully, these letters did not distinguish between the 2019 and the 2020 claims. They're just carbon copies, bam, bam. And so that's a problem. And the second letter that they sent basically was just added additional carriers that they inadvertently left off from the first letter. And again, the $20 million amount provides no legal notice as a matter of law. It provides no legal notice to excess carriers with $50 million and above limits. And going back to your DTPA question, Justice Doss, in the Stowers context, a demand to excess carriers is not effective until all the primary carriers have exhausted their coverage.
That's right. Strayhorn, I think, wrote about that. I think you're exactly right. That's right.
And it brings up the problem here. This is a similar conundrum. It's like, well, how do we know if we have to exhaust? If you give the one number to everyone, and you also say, oh, and by the way, I'll never settle for that, what is the point of that? We're not here to talk about bad faith or good faith, but it just seems to be untenable under the framework of the statute.
If the purpose of the statute was to give the parties an opportunity to settle, was the purpose not fulfilled when the insured sent a response letter back to the district saying, yeah, we'll accept 20 even though it wasn't accepted?
No, it wasn't, because here we are today. If those purposes of the statute had been fulfilled, we wouldn't be here today. But they said, of course, well, no, we're not accepting that.
Well, but that's what makes me question maybe Judge Souter got it right. Maybe Judge Souter says, hey, look, I don't know what they say, but if they say $20 million, I'm going to hold them to $20 million. We don't know at this point.
The problem is, if you look again at the four corners of the letters, they have important caveats to say it's $20 million, but it'll never be $20 million. Let me quote the language of the letters again. This is important.
Right, we're going off something that Justice Doss asked at the very beginning. If somebody wants their day in court, I mean, nothing in the statute requires them to accept the offer from the insurers. Right?
My damages are $100,000, and I'm not going to settle. I'm just going to go litigate, and I know I'm going to get $100,000.
If it's a straight-up demand that you can quantify and there's no hedging, you don't have to guess what the demand really is, because they say, we're not going to settle for that. That's a totally different story, and that's the problem. All the cases they cite have language in their demand letters that are just very clear, specific, unambiguous. They don't have the caveat there that says, we will never settle for this amount.
That's where Section G comes in, right, where if the insurer is saying, well, if you just want your day in court to rack up more attorney's fees, we're going to bring in this original letter that says, oh, it was for this, and you just did this to rack up attorney's fees.
There's a punishment there for people who give too high of a demand. That's right. But if you make a reasonable demand, it's about a demand that a carrier can understand and discern. These are undiscernible demands, and they're facetious demands when they say, it's $20 million, but we will never settle for that amount. That eviscerates the entire mechanism that the legislature enacted in 542A.
So your proposed interpretation of that language is $20 million, but we'll never settle for $20 million, is to mean it's not really $20 million.
Precisely. Thank you.
The case will be submitted. We appreciate your coming to Amarillo today, and we'll be in recess.